Hello everyone, welcome to my YouTube channel. So today let's discuss about patent infringement. So patent infringement is something that now you imagine you applied for a patent, you got a patent. Okay, patent is granted to you. Now what I will do, I will just copy your work. Okay, I will start manufacturing your product without your consent. Okay. So here, how I am copying based on that, based on the two things. Either I can say that I know that you already got the patent for it, so I purposefully started copying it, manufacturing it, and using it, distributing it, all these things. Okay, these things comes under direct infringement. Then the second case where I actually didn't do the proper research. I didn't do that if somebody owns this particular product or not. I didn't search. I didn't do any literature survey, nothing. So I accidentally ended up in making this product. Okay, where I don't know about the patent process, that this and all, because most of the people doesn't know. Most of the engineers only doesn't know what is patent. Okay. So it is obvious that the common man won't be knowing that we have to go for patent, that this. So that might be accidental. Those kind of cases will come under indirect infringement. In both the ways, you have to pay the what? It's because it's your fault now. So you cannot before using some product, you have to get the consent from that particular owner. If you don't get, then it is called as it is infringed. Infringed means maybe copied for the production, manufacturing, distribution, selling, that this everything comes. So once the patent is granted to the applicant, he owns the right to use, or maybe he can exploit the invention in any capacity. He can sell it, he can give it for a particular company for 5 years, next 5 years, different company, next 5 years, different company, until 20 years, it is his. He can do whatever he wants to do it. If anyone uses the invention without a prior permission of the owner, if at all somebody uses, if I am using your product without your permission, then that act will be considered as infringement of the invention. So this is important. One mark definition. Please remember this. Just make sure that somebody made a product, somebody got a patent. If I am using that product without his permission, if I am manufacturing that product, if I am distributing that product, if I am making money out of it, then it is called as infringement. So infringement can be classified into two categories: direct and indirect. Direct means when the product is substantially close to any patented product. Okay, if it is, imagine this pen is there and almost equal to that pen, if somebody does, I'm just giving an example. Okay, so when two things is a lot of similarity is there, it's obvious that somebody is copied. Okay, you might have heard the examples of Samsung and Apple cases, where Apple filed many cases against Samsung that they copied display, that this, all these things and all, right? Similarly, if at all you substantially closeness is there in the two products, or in a case where the marketing or commercial use of the invention is carried out without the permission of the owner of the invention, it's your product, but I am distributing it, I am without your consent. It's your product, I am manufacturing without your consent, I am commercializing without your consent. All these things comes under direct infringement, because I know and I am doing it. That's why it is direct infringement. Indirect, when some amount of deceit, or you can say the parts of your invention or a product I am using, or maybe accidental infringement. Okay, that I just told you. I don't know actually where I did it, but accidentally it happens without any intention of the infringement, then it comes under indirect infringement. So if such unlawful act has been committed, if you commit all these kind of indirect infringement also, the patentee holds the right to sue the infringer through the judicial intervention. He can go to the court and he can say that he is distributing my products without my consent, he is manufacturing my products without my consent, all those things we can claim. So if then the court of law will look into the matter, and based on the evidences it will ask them to compensate. So every country has certain laws to deal with such unlawful acts. Following reliefs are made available to the patentees. There are different reliefs will be made based on the these things. Okay. Next, what are the reliefs? The following the reliefs. Let's see. First thing is interlocutory or interim injunctions. They can go for temporary court order will be there, and based on that this thing will be action will be taken. Next, damages or accounts of the profits. Okay. These are some of the whatever the damages have been caused for a particular inventor. See, I copied, I distributed. What how it damaged your profits. Okay. Next, permanent injunctions. So permanently. So what are the different the orders which are not temporary? Okay. Permanently, the court has to give particular order. Next, it is pertinent to maintain that the central government always holds the rights. Okay, the government always holds the rights under the section 100 of the Patent Act 1970, rule number 32 of the patent rules in 2003, which are amended. So to use the invention, what right government of India has got or central government of any countries has got, they can use the invention in any case of national emergency. That's what I told. If any national emergency comes, like we had in the corona time. Okay, COVID hit, and it was one of the emergency situation, right? During that time, or any other national emergency, maybe because of the war or something like that, other circumstances of extreme emergency after notifying the owner. But even though central government using it, they have to notify to the owner that they will be using their patent for the interest of public of the nation. Okay, so that's how the things will work. That's how about the infringement. Okay, if you copy something directly or indirectly, knowingly or unknowingly, both comes under infringement. For both you have to pay. That's it. Next topic we are having avoiding public disclosure of an invention before patenting, that we will discuss in the next class.